Good afternoon. I hope you are all well. Thank you very much for joining us today on this webinar that we've been asked to put on by your charity organisation, Myelopathy org. My name is Julianne Moore and I'm one of the partners at Irwin Mitchell who specialise in medical negligence and in particular spinal injury, cauda equina and myelopathy cases. I had the pleasure today of being joined by my colleagues Rosie Charlton, who's also a specialist medical negligence solicitor, and my colleague Sue Hodgson, who is a support and rehabilitation coordinator. We're also kindly joined by Meg, who is kindly facilitating the webinar today. So she will be moving the slides on and also dealing with any technical difficulties, which we hope that we won't have today. Now you'll see from the slide there, we've popped on our rogue of galleries, our pictures there, and some of our contact details. And we also have our colleague Darren Deary, who is a partner in our Scottish office that deals with all our Scottish medical negligence claims. So what we've been asked to do and cover off today a little bit for the charity is a little bit about who we are, talk a little bit about some of our additional services. Sue is then going to discuss a little bit about what the role of the support and rehabilitation coordinator is and how she helps support our clients. And then she's going to discuss with you a little bit about how to make an NHS complaint and how to use other advocacy services when you're not happy with the care that you've been given by healthcare professionals. And then it's going to move back to Rosie and I'm going to cover off a little bit about what is medical negligence. We're going to have a look at things like time limits, how we might investigate a case and what's involved. Also look at the motivation as to why people bring complaints or claims. And then we're going to dive a little bit deeper into the sort of myelopathy cases that Rosie and I and our colleagues deal with and the common things that what we see in those sorts of cases. And then finally, Rosie's going to take you through some case studies that have all been anonymised of some of the myelopathy cases that we've dealt with here at Irwin Mitchell to bring everything into a bit of context. Now, today we have also built in some time for questions. And whilst we can't have people on the webinar to sort of directly ask a question verbally, there is a Q&A function on the webinar. So in the top box of your Teams, you should see a Q&A and you can post the questions there and then we will try and answer them at the end of the webinar. We've already had 2 pre-submitted questions, so we'll try and answer those at the end of the webinar. The webinar is being recorded, so if you can't stay, we think it'll probably be just about an hour and 10 minutes. If you find it difficult to stay on, the webinar is recorded and then you'll be sent the link afterwards so you can watch the full recording. And I think it will also be available, I understand, on YouTube. We are intending to have a break today, so if you do need to get up and move around, that's not a problem. And like I say, it is being recorded. We also are going to be arranging a bit later on in the next few months a free legal advice drop-in centre session so we can have answer some of your legal queries in particular. And again, we'll share those dates with the charity so they can share them. And as I say, you've got our contact details up there, so we're very happy for you to drop us an email or want to have a free obligation telephone call to discuss any questions that you may or may not have. So next slide then, please, Meg. So moving on, just a little bit about ourselves. We want to just give you a bit of background about Irwin Mitchell. We've been going quite a long time. We've been providing legal support for about 113 years, and we are one of the UK's largest law firms. And you'll see that whilst we're a national law firm, we've got a really good regional focus. So we've got around 13 teams around the country, including Scotland, who specialise in medical negligence cases, because we really believe it's important that as well as being national, that we have legal teams that are close to our clients in the communities so we can serve them much better. In terms of medical negligence, we are the largest dedicated medical negligence team in the country, and many of our teams, or I think all of our teams now, are market leading teams, and this has been recognised by the independent legal directories. And within our teams, we have many specialists like Rosie and I that will sort of specialise on certain types of medical negligence cases. and quite a lot of our colleagues have accreditations as well. Next slide, please. So what do we do? So all of our medical negligence lawyers only practice medical negligence. So we have separate teams that deal with PI claims, etc. So we just concentrate on medical negligence cases, and we provide legal support for patients and families where they're concerned there's been negligent medical treatment. So that could be caused by hospitals, it might be GPs, it might be dentists, other medical professionals, where they're concerned there's been, for example, a delay in diagnosis, or they've had substandard surgery. And we deal with a wide range of claims. So it can be, you know, things from cancer misdiagnosis, cases involving birth injury, spinal injury is what we're talking about today, lots of other types of cases as well, inquests and fatalities. And to support all our medical negligence lawyers, we also have a team of medical researchers who are generally ex-nurses or doctors who assist the legal teams in assessing cases from a medical perspective. So they'll help us interpret the medical records and also complex medical evidence. So they're really, useful in terms of providing that full service that we want to our clients. And as I said, many of our lawyers have specialist accreditation and are highly ranked in the independent legal directories as leading lawyers. So what I'm going to do now, I'm going to hand over to Sue, and she's going to talk to you a little bit about the support and rehabilitation service and also about NHS complaints. Over to Sue.
Thank you, Julianne. Good afternoon, everyone. Hopefully you can hear me and see me okay. So I'm just going to tell you a little bit about our support and rehab coordinator service and a bit about our role. So we're a national team of 14 health and social care professionals by background. We don't have any legal training. We work alongside the legal team. We work alongside the medical negligence lawyers, and we provide a support and signposting service. So usually we get involved quite early on when clients instruct Irwin Mitchell and they've got a claim with our medical negligence team, and we're there to provide practical support. Obviously, when these things happen, it can have a massive impact on people's life, and not just the person that's at the centre of this, the patient or the client. It can also impact the family. So we're there to support them through making adjustments and the life changes that happens when these traumatic injuries and illnesses occur. So as I've said, we're there to provide practical help and advice, and we're there to work alongside statutory services, whether that be hospitals, social care, rehabilitation units, benefit agencies. We're not there to replace these professionals. We're there to work collaboratively with them and alongside them and get the best possible outcomes for our clients. Obviously, for a lot of people navigating hospital pathways, health and social care, they may never have done it before, and it may all be quite new to them, and it can be quite a maze and difficult to navigate that on your own if you've never done it before. So that's where we can come in and offer that support and guidance. One of the main things that we do as well is to try and aim to promote early rehabilitation, again, to get the best possible outcomes for our clients. Sometimes it may be that people are being discharged from hospital and they've not had any access to rehabilitation, or they've not had any follow-up appointments. So again, that can be when we can come in and support them with that, chase up these appointments and make sure they're getting access to everything that they should be getting at the right time. Next slide, please, Meg. So one of the things that we might get involved in terms of supporting our clients is with NHS complaints. Sometimes when clients instruct Irwin Mitchell, they may already have submitted an NHS complaint. Sometimes they may do one in the course of their personal injury claim. So I'm just going to touch on sort of the complaints process, the NHS complaints process, and where you can get support and further information. So basically, anyone can complain, anyone receiving who's received care or is receiving care or an NHS service. It doesn't necessarily have to be the patient themselves. As you can imagine, sometimes people are too unwell to be able to bring a complaint themselves. So it could be a family member, as long as they've got the appropriate permission and consent. Everybody has the right to complain, and obviously complaints are subjective. What I might complain about and what someone else might complain about might be very different. There's no sort of set list of things that you can complain about. It is very individual. So as I said, everybody has got the right to complain about an NHS service or treatment, and this is outlined in the NHS Constitution, which I've put the link there. It's quite a comprehensive document, but there is a section on it outlining the everyone has got a right to complain about NHS services, and it gives you a bit more detail in that document. You don't necessarily have to make a complaint first, a formal complaint. You can raise a concern. So a concern is a little bit more informal and doesn't have to follow the formal route. That might be that you bring your concern to the attention of a staff member if you're still in hospital, and it's a way of usually getting things sorted pretty quickly and without going through the formal process. There's no set time for resolving concerns, but like I say, it is usually quite a quick process and getting things sorted before they get any, sort of get any worse. And there should always be a trust policy on managing concerns and complaints. There's not one policy that covers all the NHS trusts. They all have their individual complaints and concerns policy. So it's worth having a look on their website because they can differ slightly. So if you feel that if you've exhausted the concern route and you don't feel that you've got the outcome that you want, or if you just want to go straight to a complaint, that's absolutely fine. So the rules around complaints, you should really make a complaint within 12 months of an incident or of you becoming aware and it coming to your attention. So if there's been a mistake about your care or your treatment, but you only find out about it sometime later, then you've got a year, 12 months from that point. The time limitation, it can be extended in certain circumstances. Obviously, when people are quite unwell or they've got things going off, it's not always easy to have the time and concentration and the energy to pursue a complaint. So they are quite lenient, obviously, if you put a case forward as to why you might want to bring the complaint after the 12-month period. And as I said, everyone who provides an NHS service in England must have their own complaints procedure. The next slide, please, Meg. So just a bit about the stages of a complaint. It can be quite a lengthy process, and there are several stages that you might have to go through to get the outcome that you're hoping for and to get the answers that you're hoping for. So if you lodge a complaint, you should get an initial acknowledgement and response within 3 working days. You will then usually be given some indication of what's going to happen next, and it would go then to stage 1 of the complaints process. This is also known as local resolution stage. So this is where the NHS Trust will investigate the complaint that you put forward, and they would usually respond to that complaint within 30 days. If it's a more complex complaint, they might come back to you within that 30 days and say, actually, we need a bit longer because of the complexities of this. We need to do some further sort of investigation, but they should communicate that with you and give you some idea of the time frame. So at stage 1, once they've done their investigation, they will write to you once they've completed their investigation with the outcome of their investigation. If you're not happy with the outcome at that stage, the next step is that you could ask for a local resolution meeting. This would be a face-to-face meeting where you would be meeting with people that have conducted the investigation. You can take further questions to a local resolution meeting. If there's questions that you feel that haven't been addressed at stage 1, you can take them to the local resolution meeting. These meetings are usually recorded, and you usually are able to take someone along with you to that meeting. If at that stage you still don't feel that you've got the response or sort of the answers that you're looking for, then you can ask for it to go to stage 2. So this is an independent review. So if you're unhappy, you can ask for the independent review. And this would be done outside of the NHS trust that you've complained to. This would go to the Ombudsman, the PHSO. And the PHSO have their own 3-step process. So as you can imagine, all of this can take quite some time. Again, it can depend on the complexity of the complaint that's being put forward. So once it gets to the PHSO, they will initially do some checks just to see whether it is something that they can get involved with. That would be step 1. If they decide that it is something that they can get involved with, then they will move on to step 2, and they will decide whether they can actually investigate this complaint and the outcome further. They will then move on to step 3, which they will, once they've completed their investigation, they will obviously contact you, they will write to you and let you know whether they have upheld your complaint or whether they've dismissed your complaint. If they uphold your complaint, then they will come back to you and tell you, sort of give you some advice about what you can do or what they will do. So it might be that the PHSO write to the service and put some recommendations in place as to how they might have to change their care, or they may come to you and say, we advise you to seek legal advice. So there's a few different outcomes at that stage. Just to know, because we do have clients in our in our Scottish offices, and the process in Scotland is slightly different. So they still bring a complaint, it's still a 1-year process, but unlike England, potential clients can't pursue a complaint and a medical negligence case at the same time. It has to be one or the other. In England, somebody can pursue a medical negligence claim whilst they've got an NHS complaint underway. Next slide, please, Meg. So in terms of support and information, if you are thinking about raising a concern or a complaint, I think most people have heard of PALS, which is the Patient Advice and Liaison Service. I think also it can be known as patient experience in some hospitals as well, but effectively they do the same job. So it's a free and confidential service, but they're not independent of the NHS Trust. They are a liaison service and they're not an independent body. Sometimes they're a good first point of contact, especially if you're wanting to complain about something whilst you're an inpatient. It can be a quick way of getting things resolved. If it's about your care on a ward, for instance, you wouldn't want to go all the way through that complaints process. You'd want that sort of dealing with immediately. So PALS can be good for dealing with immediate concerns that need to be addressed sort of in a timely manner. Aside from PALS, everybody has got the right to access an independent NHS advocacy service. And these services are free and independent, and they are separate to the NHS. The advocates can provide support, explain the process, help with communication, attend meetings, and sort of represent the client. But they can't investigate the complaint and they can't provide medical or legal advice. They're there to sort of support you through the process, guide you through the process, and like I say, corresponding with the NHS Trust. They usually are a very good source of support and are independent of the NHS. Most areas have NHS advocacy services, and I've put a few links on there. To find your local NHS complaints advocacy service, you can go through Health Watch, and I think you just have to put in your postcode and it will bring up who your local provider is. Some of the main providers that I have listed, some of the big advocacy services, are Power, Cloverleaf, and Absolute Advocacy. And they may cover your area, or it might be a smaller advocacy charity that covers your area. They don't all cover the same place. It depends on where they're commissioned to cover. What I would say as well, they've got some really good resources on their website, and they usually have template letters as well that you can access. So if you want to pursue the complaint yourself, they do have template letters that you can use as well, which are really useful because they show you how to lay out the complaint and sort of the main points that you need to include and the questions that you need to ask. So that's a bit of a whistle-stop tour of NHS complaints process. Obviously there's a lot to it, and like I said, those links do provide a lot more information. So I will leave it there, and I will now hand back to Julianne, please.
Thanks so much, Sue. That was really helpful. And I know that the advocacy services where our clients have engaged them, particularly in our local area, have been really, really helpful and given, the patients and the families lots of information. Just in terms of Scotland, Darren, one of our colleagues, also asked us to say that because the complaints process can take quite a long time in Scotland, and obviously I'm going to talk about time limits in a minute with claims, it might be, if you're thinking about making a complaint, it probably at the same time before you do that, it might be useful for you to contact a specialist medical negligence lawyer to discuss, because I understand the complaints can take sort of 18 months or so, and then obviously there's a certain time limit you've got to bring a claim. So again, I think his advice at that stage would be, if you think you want to make a complaint and you're out of hospital, then perhaps speak to a specialist medical negligence solicitor at the outset, would be his advice. I don't think we've had any questions through on the Q&A function as yet. So Megan's not sort of shaking her head. So if you do want to, please post some questions in there. So we've got some already that have come through, so we can discuss those. I think I don't know when Megan, if you can actually demonstrate by just putting a little hello in the Q&A function so people know where it is, will be helpful, and we'll try and answer any questions. No questions silly at all, and that's why it's a question. So we're going to, once she's just pops that in the Q&A function so you can see hopefully where it is, we're going to move on to the next bit. So we're moving on to what is clinical negligence, and we just really wanted to do this because I don't think people necessarily quite rightly understand the process, and and what is why we have clinical negligence, what it's intended to do, etc. And Rosie at the end of the webinar today is going to take you through some case studies, so we thought it was really useful in preparation for that to go a little bit about the law and what's involved in order to put those case studies into some relevant context. So what is clinical negligence? We're not going to give you a very long law lecture, but there are some principles that you need to understand, and we explain this to all our clients so we can manage expectations really about these claims. So it is a law of tort, so it's a civil wrong. It's not a criminal case. There's no punishment arising from a clinical negligence case. It's not a disciplinary procedure or process. So if you are concerned about the conduct of a healthcare professional, there are other avenues that you can go down to look at that, and that will be through their regulatory body, such as a General Medical Council if it involves doctors, or if it involves nurses or midwives, that's a Nurse and Midwifery Council. And then there are some healthcare regulators for what we call health professionals allied to medicine, so like physiotherapists, radiographers, etc. So they are a different process to medical negligence. The main thing for medical negligence is, if you have a successful claim, is to receive compensation. And sometimes lawyers use the word damages, so there's two words that people tend to use when it comes to compensation. And what we wanted to do was point out that compensation, despite what you see in the Daily Mail about someone winning damages or winning compensation, compensation is not a windfall. And the reason why it's there is the law of negligence is there to try and put that injured person as far as possible back into the position they would have been had the negligence not occurred. So that would include monies or compensation for their pain and suffering, the impact on their life. They may be unable to return to work, so they've got loss of earnings. They might need specialist therapists. They might need specialist care. They might need adaptations to their property. They might need specialist equipment. And often a lot of that isn't available on the NHS or statutory services because it's quite thin in terms of the funding. So if they do have a successful claim, that will allow them to have monies to engage those privately, because the aim, what we want to do, is to let our clients to lead a fulfilled life despite their injury. So that is the whole purpose, to say, as to compensation. So when we're looking at medical negligence claims, it's also important to note the burden of proof, the person that has to prove the claim. It's not the defendant or the hospital, the trust, it's actually the patient, and we call them the claimant. So, that is important, that, you're actually bringing the case with support from your lawyers and the medical experts. So just turning to medical negligence, there are effectively three things that you need to establish in order to succeed with a claim. The first one is that all patients are owed a duty of care. So if you go and engage and have healthcare services, they are provide you and owe you a duty of care. And there's two main questions then that we look at as medical negligence lawyers, and also the courts look at. First of all, they'll look at whether that duty of care was breached. And then there's secondly, if they can identify if that duty of care was breached, did that breach cause the injury or materially contribute to it? So just breaking those down, if we look at breach of duty, it is actually quite a high threshold, and how they actually measure this is that you have to show that no other responsible body of a practitioner practicing in that clinical field would have done the same thing. So the standard of care, or that is actually measured against the standard of that practitioner's peers, not against the standards that they're set by the lawyers. So in plain English, if you're looking at a standard of care provided by an orthopaedic surgeon, then we would have to look at the standard of care given by all orthopaedic surgeons, and did that fall below that acceptable standard. So it's not a gold standard, it's basically the basic standard, and it has to be the standards that were applicable at that time. So you'll hear different words if you speak to lawyers. They'll talk about a breach of duty or a failing in a standard of care, and that's what they mean in terms of that first limb. If you can get over that first limb, then we look at the second element, which is what we call causation. So if we can identify that's been a breach of duty or a failing in the care, you then have to prove that more likely than not, had that substandard care not been provided, you would have avoided the injury. So you've got to prove both elements. You've got to show that that substandard care has made your injury worse than what it would have otherwise have been. And that's often, in these sorts of cases, can be tricky, because you can have cases where there's been really, really poor care, but ultimately, in some cases, that the poor care wouldn't have made a difference to the outcome, because the outcome would have been the same. And often when we're trying to explain this to clients, we might say, for example, if you had a case involving cancer and there was a massive delay in treating it or diagnosing it, on some of the types of cancers that we have that can be quite aggressive, even if it had been diagnosed earlier, it wouldn't have made a difference to an outcome, so you're unable to establish a claim. So you have to prove those two elements. You have to prove there's been a failing or a breach of duty, and then you have to, if you can then move on, you then have to show that failing has then caused the injury or made that materially worse. And as I say, the burden of proving the case is on the claimant. Next slide, please. So moving on to time limits, this is again what we were just touching from before. There are certain time limits in which you have to bring a claim. And we could sometimes, again, if you hear lawyers talking about this, they might talk about the limitation period. And that's effectively what they're talking about, is a time limit to bring a claim. So in England and Wales, it's 3 years from the date of the alleged negligence. And we sometimes call this primary limitation, or the date you first knew or suspected that something had gone wrong was related to the treatment that you had. And we call this a date of knowledge. Now, it is not as simple for everyone, because there are different time limits for children and for adults who what we call lack capacity. So for children in England and Wales, they have effectively until the 21st birthday to bring a claim. And in Scotland, they have until they're 19. For adults who don't have capacity, if they haven't got capacity at the time and they still haven't got capacity, then the clock doesn't start running. But if there are time limits, if you fail to bring a claim within that period, then your right to do so may be lost. So it's really important, if you think you've got a claim, that you speak to a specialist medical negligence solicitor as soon as possible, so then they can take steps to protect any time limit. Next slide, please. One of the things that we wanted to cover off today was briefly how we investigate a claim, and this is something that we go through with all our clients when we initially speak to them, because I think it's really important that they understand the process when things will happen. They understand about timescales and different things that may or may not happen in a claim, because I do think it really helps to manage expectations so everyone's aware what's involved. So just generally, in terms of Irwin Mitchell, not just in terms of cervical myelopathy cases, we get thousands of inquiries each year. And with our dedicated teams and our specialist experience, we carefully screen through all those inquiries, and we filter out quite a few at the early stage where we think actually it's not something that we can help with. And that's usually because we think there's probably going to be no breach of duty or causation from our experience. Sometimes it might not be a claim that's related to medical negligence, it might be at something else. And also some of the claims might be that the actual compensation, the value of the compensation may be quite small, and the cost of pursuing the case may outweigh that. So it's not in the client's best interest or the court's best interest to pursue that case. When we can't take a case on, we don't just leave it there. We always try and signpost any clients or callers for right support. So sometimes they might be more beneficial going down the NHS complaints route to get some answers, or we will direct them to a charity or organisation that we work with that we know have got support groups and lots of information. So today you've come from myelopathy org. So again, people with cervical myelopathy or myelopathy, again, we would signpost them to that organisation as well. If we think a case does has potential, then we pass it on to the relevant local regional medical negligence team, where our specialist medical negligence lawyers will carry out a second review. They might come back to you and ask for some further information, and sometimes they may go off and seek an informal expert view at that stage. Again, if we don't think from that second screen it doesn't look like it's got strong enough prospects to go forward and investigate, again, we'll make sure we do all that signposting. If when we've looked at it for that second screen, we do think it actually merits some sort of investigation, then we'll start that. So we'll sort out the funding, and again, our team will go through all the different funding options with you. And then once the funding's in place, we then start our formal investigation, and we would obtain copies of all the relevant medical records, any scans. If there has been a complaint, we'd ask the hospital to provide copies of all the complaint correspondence. Sometimes hospitals carry out independent hospital investigations, so we'd ask for copies of that investigation report. Sometimes there might be statements and those that are attached to that investigation, so we'd ask for sight of those as well. For lots of procedures, etc., there's protocols, so there'll be the national guidelines that we'd look at, but also hospitals will have local protocols and guidelines which are applicable at the time of the treatment, and again, we'll be asking for sight of those. And very importantly, we also make sure that we have our client's version of events, because often sometimes you get the medical records and they tell a different story to what the client has told you as well. So we make sure that we've got all the evidence in the round. At that stage, then we go off and get our independent expert evidence to look at those two questions we talked about to see whether or not the expert considers there's been a failing in the standard of care or a breach of duty. And if we can get over that hurdle, then we will then go off and get further expert evidence to look at that question as to causation. So had that failing, caused the injury or made the injury materially worse? Now, at that stage, if the expert evidence comes back and it's supportive, what we do in England and Wales, we go through something called the Clinical Disputes Pre-Action Protocol. And before we issue any formal court proceedings, we would send what is called a letter of claim. And that would go off to the defendant. So it could be a defendant GP, it could be a defendant hospital trust, it might be more than one defendant if there's been different touch points in that patient's care. And we would set out the facts as we know them from the medical records and the client's versions of events. And then we would set out the allegations of negligence, so those failings in the care, and then the injury it's been caused. And the idea of that is to see if the parties can try and resolve the matter without issuing formal court proceedings. And that's a step that all clinical negligence cases in England and Wales are required to go through. There's a different scheme in Scotland, which I'll talk about in a minute. Once that letter goes, then the defendant then will start their own investigation. They'll gather their evidence, they'll talk to the clinicians involved, they'll sometimes go off and get independent expert evidence, and then they'll come back with their response, and we call that a letter of response. And that's usually the first time you'll know what the defendant's stance is going to be. So whether or not they're going to admit negligence, so they're going to admit both breach of duty and causation, or whether they're going to deny it. So sometimes they'll do a full admission at that stage. And if they do, then we would ask the court to issue proceedings and get judgment entered. So that means that the liability has been recorded onto the court file, that liability has been accepted. And then what we would do then is go off and get further expert evidence to look at the impact of the negligence on the client and the injury and what they need to go forward, and then obviously come up with some sort of settlement for the client's ongoing and future needs. If, however, they sometimes will come back and they might have a full denial as to breach of duty, so they don't believe there's been any failing in the care, and they also may deny causation. Sometimes they'll admit there's been a failing in the care, but then they'll deny that that failing has altered the outcome. And at that stage, we would have a look at why they're saying that. We'd also then go back to our experts. We might involve a barrister at that stage to look. And if we don't think that their denials stand up to logical scrutiny, then we would take steps to issue formal court proceedings. And at that stage, we would be looking at going down a different track to see whether or not we can resolve liability, or ultimately we'd ask a court, we go to trial to see whether or not they could have a liability judgment in the claimant's favour. Now, most clinical negligence cases don't end up in trial. Most will either at that stage settle later on down the line, but there is a small amount of percentage. I mean, I've been doing this job 20 odd years and I've probably been to trial twice. So that just goes to show you how often cases go to trial, but it's always the end point. If, however, we do end up going to trial, cases can take from start to finish about 3 to 5 years because all the processes that we have to go through as well, just to give you an idea of timescales. Sometimes, if there's been a hospital independent investigation before we've gone off and got our expert evidence, so sometimes clients will approach us, there's already been a hospital investigation or there's one going on at the same time. If we get a sight of that investigation and effectively there are clearly failures marked in that investigation, then what we would do, we would send a letter of notification off to the hospital or the doctor and invite them to admit at that stage to see whether or not to try and resolve matters quicker. That sometimes works, sometimes it doesn't, and it depends on how detailed the hospital investigation is, but we have used that sometimes in some of the cases to sort of shorten the time scale. Now, in terms of Scotland, effectively, there isn't, I understand, a pre-action protocol, so there's not the opportunity to send a letter of claim and letter of response. In Scotland, most of their cases automatically go into proceedings. So it's a lot more adversarial, but again, similar to the ones in England, if they go into proceedings, generally some point down the line, unless the expert changes their mind or something material change, is they usually settle before trial. And that's the main difference. I understand in Scotland there is a working party at present that's looking at trying to bring that in, so it's more in line with England and Wales as well. But at the moment they don't have the facility to go through that pre-action protocol like we do in England and Wales, which generally works quite well for us because we do often, if we've got supportive evidence, we can get admissions that way. So it kind of again speeds things up. Next slide, please, Megan. We also wanted to talk a little bit about what makes a patient want to complain, like what Sue's talked about, or to pursue litigation. So everyone will probably say, oh, it's because they want to get some compensation, but actually in majority of cases initially that's not what people come to us before. They come to us because they're looking for answers. They don't know what's happened to them, why things have gone wrong, and they want some answers to their questions. Often it's quite evident on some cases that, you know, something's gone wrong, it shouldn't have happened, and that patient's really interested, or their family, in change. They're hoping that their case will lead to new procedures, new protocols, and which could prevent it happening in the future and happening to someone else. And we certainly see that where it's been a serious injury, or for example, sadly the patient's died, there's that motivation to prevent it happening to someone else. The other thing often families will want, they want an apology, they want an acknowledgement that harm's been done and something has gone wrong. That's quite powerful. So often when we've investigated a case, whilst we're looking for compensation, if there's been a finding of fault, and that's contained in the hospital's letter response, they'll also include a letter of apology, which is quite powerful for a lot of our patients and the families. We often see where there's been a breakdown of trust between the patient and their family and the actual healthcare provider. You feel like sometimes there's been a bit of a closing of shop. You know, no one's giving them the answers what they need, and you know, some comments that are made are quite insensitive and quite defensive. That can also mean that people want to come and have a chat to lawyers to get some questions. But as I said right at the beginning, the main point really is to, if we've got a supportive case, is to provide compensation or monies for their future needs, you know, for that specialised care, the equipment, the housing, the therapies, etc., which a lot of the time is not available on the state. So important that we want to try and put them back in the position they would have been had the negligence not occurred. Next slide, please. So my last two slides before I hand over to Rosie was really to talk about myelopathy claims, because I know that's what a lot of you might be interested in. But I just wanted to share a little bit about how we became involved with myelopathy org. So Helen, who is the chair of trustees, approached me to ask us if we could come on board to consider providing legal support to the members of the charity who may have concerns about their treatment. For example, we often see where they think there might have been a delay in diagnosing their myelopathy, and if it had been diagnosed earlier, they might have ended up with a better outcome. And Helen has spoke to quite a few other charities that we work with, particularly spinal and cord equina charities, who had actually recommended us. And Helen, I know, wanted to ensure that the people that and the legal panels that were sort of supporting the charity had the experience of dealing with these types of claims. So we've recently become a trusted legal partner of the charity. But I also wanted to say, before we go and talk about myelopathy claims in more detail, is that for us at Irwin Mitchell, it's not just about the claims. You know, we are really committed to playing our part in improving patient safety and patient outcomes, and also for individuals who suffered from myelopathy. We know in these types of cases, getting an early diagnosis is the key to getting the best outcome. So as well as it's sort of dealing with claims and legal support, we also are very committed to raising awareness. So many of our teams, including myself and Rosie and many others, and Sue as well, and other colleagues around the country, go out and we work with NHS trusts, we work with GP practices, we work with therapists, etc. And we do a lot of training to them. And we basically share some outcomes of some of our cases on an anonymised way of showing some of the case studies. We talk about what it's like for families and patients and what's important to them. And we try and raise an awareness and upskill about different conditions and sort of show what best practice should be with those conditions. And there's a real good dialogue between us and a lot of the local NHS trusts because we do that. And again, we think it's really important to try and raise that awareness and play our part in improving patient outcomes. We also do lots of webinars like this. So I know we've done it specifically for the charity today, but we do a lot of healthcare professionals. We've been doing them for about 4 years because we know that sometimes the healthcare professionals don't have the time to spend a day at a training session or half a day, and they can bob on to a webinar for an hour and a half, listen or watch it later on and share it around. And we know that's been quite powerful. So we've done all sorts. So in the spinal community, we might have done it on earlier diagnosis, and we've had medical speakers, we've had clients with lived in experience, we've had psychologists. We also look at after diagnosis, and we've looked at sort of best ways in terms of therapies and treatments. It can be physical treatments, it can be psychological treatments. We've done things on psychosexual dysfunction in spinal cord injuries, etc., because we really want to sort of give people that information about the services that they can act. And later on this year, we're putting together one specifically on myelopathy cases as well. Next slide, please. So we also wanted to share some common themes that we see in the myelopathy cases that we deal with at Irwin Mitchell, and Rosie and I have put these together from the cases that we deal with. So we know one of the big things is that we often see clients come to us because they're concerned that there's been a misdiagnosis or a delayed diagnosis of their condition. Often, with the clinicians they've seen, and it can be if they've been to the GP or they might have attended a walk-in centre or an A&E department. And we know that we see lots of cases like this. And we often see cases where there's not been a thorough examination that's been performed, or they've not taken a detailed medical history, which might mean some what we call red flags are missed. And that's really, really important in these types of cases. So what are red flags? Well, the clinical signs which should alert the clinician to the possibility in these sorts of cases that there could be compression of the spinal cord. And there are often those really early neurological signs, such as sort of, dropping things, hand clumsiness. It might be people might be falling over quite a bit. They might have what we call a gait imbalance and sort of walking a bit funny. There can be sensory changes, or there can be changes in their bladder and bowel. And those red flags would, indicate there should be a further urgent assessment to see what's underlying this. These symptoms we generally see should sort of trigger an urgent referral for an MRI scan and a specialist review. And we often see cases where this has not been done, that there's a failure to recognise, which is then causes delayed diagnosis, which then can sometimes lead to avoidable deterioration, so a worse outcome for that patient than what they would have otherwise had. I think the other thing we see as well, and which is really important in any clinical setting, is what they call safety netting. We sometimes see that that's not given, and that's in cases whereby someone's seen a patient, they're not quite sure what's going on, but actually the symptoms are evolving, something's not quite right. It could be one thing, it could be the other. So it's really important then for the clinician should inform and equip the patient with the information to look out for what signs and symptoms to look out for in case they deteriorate. So for example, in these sorts of cases, it would be like increasing numbness, it could be deteriorating balance, it could be new bladder and bowel symptoms. So these are symptoms you should look out for. And then if you start having these symptoms, who you should go and speak to, and the pathway to do that. sometimes as well, it's important in certain cases that the clinician also organises a follow-up appointment to see if things are getting better or not, because that's a good opportunity as well if things are evolving. And again, Rosie and I will see many claims where safety netting has not been carried out, the patient's not been given that advice or that information, or it's inadequate, or it's poorly documented. And the big thing on this is then the patient goes home, carries on deteriorating, and doesn't realise the seriousness of their symptoms and what they should be doing at that stage. So that's something that we see quite often. It's really, really important that clinicians do that. We also see delayed investigations. So someone's got symptoms which mandate an urgent investigation, and there might be delays in arranging scans or operating, which then means that the symptoms get worse. So the symptoms cause further deterioration, and then that sort of loses the opportunity to get a better outcome. We see it quite a lot sometimes with delays in MRI scans. So in MRI scans, they are the key diagnostic tool really for cervical myopathy, in addition to that clinical examination, because they will give you the view of whether or not the cord's being compressed or there's any kind of signal changes which shows that it's on the way, so to speak. So we often see cases where, despite the red flags that a patient's exhibited or told the doctor or from the examination, MRI scans haven't been requested. Sometimes it's the priority the scan is given, so it's been requested, but it's been put down as routine rather than urgent. So it means that that patient can be waiting for months and months and months before they get that scan. And meanwhile, the symptoms are deteriorating, and then the spine's being decompressed, and then they've gone into a much worse situation. Sometimes we see cases where there's been administrative errors, so the scan hasn't been requested, or it's been sent down the wrong triage route, etc. Because we do know that, and we have cases where a delay in obtaining an MRI scan has led to a worse outcome. So again, it's really, really important that we get those done timely. We also sometimes see delays in operating. So once the myelopathy is confirmed, particularly if the symptoms are progressive, timely surgical decompression to release that pressure on the spine is essential to prevent any further permanent neurological injury. So sometimes we'll see delays in referring the patient to the specialists or the spinal surgeons, or sometimes there can be delays in listing the patient for urgent decompression surgery, or to appreciate this is a progressive deterioration. This is getting worse in this patient, and we're not doing anything about it, because as we know, as we said, the longer the spinal cord remains compressed, the greater risk of irreversible disability. The other things that we see is that there are sometimes delays in transferring patients. So patients might go to local district general hospital, and most spinal specialist services are kept centrally in a region. And so sometimes there's a delay in arranging for that referral to a specialist centre, or if they come in a sort of urgent critical state, then they need to be transferred to that specialist centre. There sometimes can be delays in arranging ambulance transfers, or there might be delays by the receiving hospital to either refuse to accept that patient or delay. Sometimes we have cases where someone's at the district general hospital and they're clearly deteriorating and no one's noticing that, and they're still waiting to be transferred. They've not escalated that up and moved it along quicker. And again, we know that that's really important, that we capture them and deal with them quickly as possible. I think the final two things that we see, probably less on this one, probably a little bit more on the final one, is poorly performed surgery. So again, you will get the odd case where the decompression or stabilization surgery that's been carried out to release the pressure from the spinal cord has been carried out negligently, so it's not been carried out to an acceptable standard, and that's caused a more serious injury. But we also sometimes see cases where there's been a failure to recognise some post-operative complications, such as, sometimes you can develop a blood clot, or you can have an infection, or sometimes there's what we call leakage in the cerebral spinal fluid, or people can develop like an infection or sepsis. So the actual complication, the development of it itself is not negligent. That's seen as what we call a recognised complication. What can be negligent is if there's a failure to detect and timely treat that, because again, that delay can lead to a much worse outcome. So before my voice goes, I'm going to hand over to Rosie. I've kind of taken you through very quickly the cases, and Rosie's going to talk to you about some case studies, and then I'll come back with some of the questions we've got from the Q&A. So thank you.
Thanks, Julianne. Good afternoon, everybody. So before I go into these case studies, I just wanted to say that some of the content is quite sensitive, so some of it may feel a little bit close to home. So if you'd prefer to mute or to log off for this section of the webinar, you're welcome to do so. I won't be offended at all. And I've chosen these two case studies really to put some of the points Julianne was discussing into context, really. So starting with patient A, this was a lady in her early 70s, and this case concerned the care that she received from her GP over quite a long period of time. Actually, it was about just over 18 months in total. And that the chronology in this lady's case began in the January, where she started having a sensation of pins and needles tingling in her fingertips, particularly in her thumb, index finger, and second finger of her right hand. She went to see her GP and was told there's not really anything to worry about, and to come back in 1 month to be reviewed. And over the course of sort of early that year into the spring, Mrs. A began to experience problems with sensitivity to hot and cold in both of her hands. The pins and needles continued, and she started having the same symptoms in her left hand as well. And the symptoms deteriorated in that the sensation actually started to become painful. So in the May, Mrs. A saw her GP, who ultimately became the defendant in this case, who did actually identify neuropathic symptoms in her upper limbs, so the tingling, the pins and needles. And at this appointment, medication was discussed with her, and duloxetine was prescribed. Again, nothing further was done. No referrals were made, for example, for any further investigations or anything like that. And she was simply advised to come back in a month's time to be reviewed again. Thanks, Meg. So later that month, Mrs. A returned to see her GP again. So there hadn't been any improvement in those symptoms, and the medication she'd been prescribed hadn't really made much of a difference. The pain had worsened by this stage to the point that it was waking Mrs. A up during the night, and during the night she was having to sort of squeeze her hands together for an hour or so to relieve that pain. And at this consultation, the GP did actually arrive at a diagnosis, and the diagnosis he gave was of carpal tunnel syndrome. Again, no further investigations, tests were requested. No referral was made to the hospital, anything like that. And she was simply advised to rest and to consider purchasing some splints to support her wrists, her hands. So the chronology continues. In the June, the symptoms hadn't improved at all with the splints, with the medication. And there'd been a change slightly in that the symptoms seemed to worsen when she sort of bent forwards. So Mrs. A returned to her GP. No examination was done of her arms, her neck. The duloxetine was started, and she was given some new medication instead, so pregabalin to try and help the pain that she was having. Again, still no referral, no tests, no investigations at this stage. So into the summer, things still hadn't improved, sadly, for Mrs. A. So back she went to see her GP. And at this time, the possibility of MS was discussed. So the GP felt that this was unlikely because her symptoms didn't quite fit with a diagnosis of MS, but it wasn't possible to rule it out. But despite thinking this was possibly a case of MS, no referral was made to the hospital to investigate this further. No scans were arranged, for instance. Thank you, Meg. So continuing on later into the summer, the symptoms in her hands, her arms had evolved, so the distribution had increased. And at this stage, the GP felt actually this probably isn't MS, but this might be a B12 deficiency that was causing these symptoms. So the plan was for the medication to continue, but also for Mrs. A to have some blood tests just to check her B12 levels. Continuing on into the October, Mrs. A continued backwards and forwards to her GP, still having the pain, the pins and needles in her hands. The pregabalin had helped a little bit, and she took slightly more than she'd been prescribed. So the advice was to not do that, but little else in the way of any advice or investigations. And at this stage, the GP came back around to his original suspicion of carpal tunnel syndrome. Into sort of later in the autumn, the GP felt actually this probably isn't carpal tunnel syndrome, but still there wasn't any onwards referral for a specialist opinion, any tests, investigations, any scans. So quite understandably, by the following spring, Mrs. A was at the end of her tether, really, for want of a better expression. And she'd actually arranged a private consultation with a neurologist herself. Thanks, Meg. And the neurologist took quite a careful history of her symptoms. So when things started, the nature of the symptoms, what made them worse, whether there was any improvement. And the neurologist recommended some nerve conduction studies, which identified chronic cervical root pathology. So effectively an issue in the cervical spine, and that led to an MRI scan which showed flattening of the spinal cord in her neck, and it was actually that issue with the spinal cord that was causing her symptoms. And Mrs. A was subsequently referred on to a neurosurgeon. And the neurosurgeon, having assessed her, having looked at the scans, the history, arrived at the diagnosis of cervical myelopathy straight away, effectively. And so Mrs. A then underwent the discectomy and fusion. Fortunately, the operation went as well as it could. But of course, Mrs. A had been backwards and forwards to her GP for just over 18 months with these symptoms. So sadly, the outcome from surgery was not as good as it might have been if she'd been diagnosed and treated much sooner. So Mrs. A in this situation was left with persistent sensory disturbance, clumsiness, and she struggled to perform sort of fine movements with her hands. And she also had quite persistent shooting pains in her hands, in her arms, as well as a poor gait and muscle weakness in her lower limbs, which meant that she was quite unsteady on her feet. She often tripped, she often stumbled. And of course, those physical symptoms had quite a dramatic effect on her mental health and her psychological well-being as well. Thanks, Meg. So to investigate this claim, so going back to what Julianne was explaining, first and foremost, we obtained copies of Mrs. A's medical records, all of her scans, the nerve conduction studies. And at that stage, we obtained input from an independent GP to comment on the standard of care that Mrs. A had received. And the independent GP we had instructed was really quite critical of the standard of care that she'd received, in that that there didn't seem to be from the records any real thorough history that had been taken, or any proper examination of Mrs. A. And the GP expert, that their opinion was that given Mrs. A's repeated attendances at the GP surgery, the lack of improvement, and in particular the suspicion of MS, and that should have warranted a much earlier referral to a neurologist or a surgeon for those symptoms to be explored properly, and that would have led to further tests, further investigations. So looking at the causation side of things, as Julianne was explaining, what we needed to get then, having identified what our GP felt were breaches of duty, was input from a spinal surgeon to look at what the outcome would and should have been if the earlier diagnosis and earlier treatment should have been made. So we'd instructed our spinal surgeon to look at these issues for us. And that expert was effectively able to pin down what the likely outcome would have been at each stage of Mrs. A's treatment. So this involved quite careful information being taken from Mrs. A herself concerning the progression of her symptoms, her deterioration, and input from her husband as well, which meant that our spinal surgeon was able to pinpoint what exactly the likely outcome would have been had a referral been made at each stage of this chronology. And as well, we also obtained input from a consultant psychiatrist to consider in more depth the psychological impact of all of this on Mrs. A. So of course the long-term symptoms, the impact on her day-to-day function, quality of life, but importantly the impact of the chronic pain as well. And I'm pleased to say that this case concluded successfully. We were able to settle this case out of court. And going back to what Julianne was explaining, the issue of breach of duty, we were able to resolve quite easily in this case. It was fairly clear cut. But what took more investigation was the issue of causation. So really identifying what the course of her treatment should have been if she'd been treated appropriately, and what difference to the outcome that would have made. Thanks, Meg. So moving on to patient B. This was actually quite a young lady in her early 30s, and the suspicion here was that she'd actually developed the myelopathy as a consequence of a sporting injury, which had caused the damage to the disc, which subsequently caused the myelopathy. And as you'll be able to see, the chronology of events here is quite different and illustrates some of the other points that Julianne was discussing. So patient B attended A&E, reporting back pain and what she thought was a muscular injury to her neck. When she attended A&E, she was given some pain relief, neck exercises, and was discharged. A couple of days later, patient B re-presented to A&E, and by this point her symptoms had deteriorated in that she now had intermittent pins and needles in her arm, numbness in her hands, and she also had weakness in her legs, and her legs were sensitive to touch. And at this stage she'd also developed problems urinating, bladder dysfunction. So when she arrived at A&E, she was triaged, she was assessed in A&E quite quickly, and she was referred on to the neurosurgeons, who requested an MRI scan of her full spine. So far so good, I think, in terms of the care that patient B received at this attendance. And the MRI scan took place urgently out of hours. And the report confirmed that there was no evidence of cauda equina compression, so no evidence of any issue in the lumbar spine. Nothing untoward anyway. So patient B was discharged. But unbeknownst to patient B, it was actually documented in her records that that the MRI scan of her cervical spine couldn't actually be performed out of hours, and actually needed to be performed as an outpatient. So it was written in patient B's records that she needed to follow up with her GP for this to be arranged. But this wasn't actually communicated to patient B at all. So as far as she was concerned, everything was fine, that there was nothing to worry about, and that the symptoms would just resolve. So patient B went about her life as best she could. A couple of weeks later, things had deteriorated again in that she was suffering from tremors, weakness, numbness in her legs. Her bladder symptoms had worsened, and she'd also started having difficulty opening her bowels by this stage. So she went to see her GP, who referred her immediately on to a neurologist. Thank you, Meg. And an MRI scan of her full spine was performed here, which identified severe stenosis at C5, C6 and C6-7. And she was then referred on to the neurosurgeons. And unfortunately, as you can see here, once the neurosurgery referral had been made, there was a couple of days before the actual surgery itself took place. But eventually, she did undergo the anterior cervical discectomy. Thanks, Meg. So in this case, it's of course not slightly different set of facts. So what we needed here first and foremost was evidence from an expert in emergency medicine, an expert in neurosurgery, and an expert in radiology. So to really pin down what was happening when B attended hospital, whether the referrals were appropriate, and from the radiology perspective, whether it was acceptable for only half of the scan that had been requested to be performed, and to look at how the logistics work there. So if it isn't possible for the requested scan to be completed, how should the radiology team communicate with the surgical team who'd made that referral to make sure that nothing slips through the net? So having obtained the evidence from those experts, that the allegations we made to the hospital trust here were that they failed to perform the whole spine MRI scan, which was crucial given that B's symptoms were strongly indicative of cervical myelopathy. If that had been done, the MRI scan would have shown that B had suffered injury to her spinal cord caused by degenerative changes in her neck, caused in turn by a suspected sporting accident. She would have been referred to surgery, which would have taken place significantly sooner than it did in fact. And although patient B would have probably had some degree of ongoing symptoms, the progression, the worsening in her symptoms would have been prevented, so that the severity, the spread of the numbness, the extent of the gait dysfunctions and the muscle spasms would have been much improved. Her bladder and bowel function would have been lessened or prevented in its entirety. And this case is actually still ongoing at the moment. So we've had a response, the letter of response from the hospital trust, accepting breach of duty in this instance, accepting that the scan should have been done. And so really the outstanding issue here is what difference the earlier diagnosis, the earlier treatment would have been. So going back to what Julianne was saying, we're just in correspondence with our experts at the moment to determine whether they stand by the evidence they'd given initially. If they do, the likelihood is that this patient B's case will enter the court process and become subject to a timetable that the judge sets. And that's the end of patient B's case study. So thank you, everybody, and I'll hand back over to Julianne.
Thanks so much, Rosie and Sue. I mean, it's really helpful. I think when we can sit here and we can talk about the legal tests and the sort of legal process and what's involved, but actually having real life case studies, hopefully, as I say, brings that all into context and gives you some flavours of some of the cases that we deal with. So Thanks very much. We've had about 3 questions, so I'm going to attempt to answer them. Some of the questions are medical related. I am a lawyer. I do have a medical background, but it's many, many years ago. So I'm obviously going to answer them from a lawyer perspective. So again, it's not giving you any medical advice. That's what a lawyer would say. But yeah, we've had 3 questions. So thank you very much for the questions. We'll attempt to answer them. So the first question we got was, what is the difference between cervical stenosis and degenerative cervical myelopathy, or for short DCM? So from our understanding of dealing with these cases, your cervical stenosis is where you've got a narrowing really of the spinal canal, and that can be caused by degeneration in that area. It can be sometimes the spinal disc will bulge. As we get older, sometimes, like I am now, I'd probably, if you looked in my spine, I might have, particularly sitting down at a desk all day like this, might have some bony growths around that area, which then can cause a bit of narrowing of the spinal canal. Or we can all, as we get older, we know we can get age-related changes. So in a lot of cases, there isn't really any symptoms. We call it asymptomatic. And if you actually would then scan those individuals, sometimes you can see that narrowing, but because it's not compressing or causing any problem with the spinal cord, it's completely fine. If some people do get a bit of symptoms, I understand that sometimes when we speak to people, they've got a bit of neck pain, they might have a bit of arm pain, they might have a bit of altered sensation or weakness, but there's not really those kind of red flags when we talk about in terms of myelopathy, where they've got problems with hand control, coordination, walking, etc. With degenerative cervical myelopathy, that's when it's kind of moved on a little bit. And if you think about the case that Rosie's just talked about, that's when the stenosis or narrowing, or someone might have an injury where it's now compressing the spinal cord. So it's either progressed, or it's like an injury that's suddenly compressing the spinal cord, and that tends to bring a lot more symptoms, because by this point, I suppose the cord's being kind of squished, and it's sort of like malfunctioning, if you think of it a bit like an electrical connection. So you'll see in those sorts of things, it's not just irritating the nerve, it's actually compressing it. So you'll see a bit more in terms of loss of hand dexterity. So you might say sometimes our clients will say I had difficulty with writing or fastening my buttons, or I was falling down a lot more, or I was walking funny, my gait was different, or my limbs felt really heavy or really weak, and I was quite clumsy. And then, as Rosie said in that case study, you'll sometimes see bladder or bowel changes. And we know that in the DCN, the sort of cervical myelopathy cases, that capturing that, diagnosing it needs a specialist review, it needs an MRI, because probably in those kind of moderate to severe cases, they may need that surgery to sort of release, decompress the spine to prevent any further deterioration. I think again, this is not a medical, I'm not a sort of medical professional, but in the ones where there's a narrowing, it's just obviously monitoring that, and then sometimes they can recover in terms of having some physiotherapy. It might be a bit of pain relief, and I think lifestyle adjustments, probably sitting down like Rosie, Sue and I do all day, is probably not so good. So that's the kind of from our understanding and the work that we do on the case, is the difference between cervical myelopathy and cervical stenosis. So we've got another question. Another question that was sent was, can we give any indication of our success rates? Well, that would be fantastic in medical negligence, and I hope this question was one that was sent before our presentation through. So again, every case is different, and you can see sometimes how difficult medical negligence cases are. I mean, it's all that me and my team deal with, and every case depends on the individual's circumstances, the symptoms that were there, the people that were saw, and the steps that were taken. And in a lot of cases, many will succeed at that breach stage, because there might, for example, be a clear delay in diagnosis of MRI or referral, etc. What can be more tricky in in these cases, in a lot of medical negligence cases, is what Rosie's just talked about and what I've talked about is causation. Because again, you know, the deterioration can be gradual, it can be multifactorial, and again we have to look at that independent expert evidence to see if there was a delay, you know, whether or not that delay has changed the outcome and would have been, you know, given a better outcome. So what we can't give at this stage is to say, oh yeah, we've got, you know, a 50% success rate of, you know, establishing a claim. We go through that rigorous screening process like I talked about. So on some cases we know from experience, you know, the length of delay, what was involved, there wouldn't be anything there to investigate. On other cases, I say we get independent expert evidence, and all the experts that we use are recognised experts. So, you know, we look at each case is, you know, has to be based on their individual merits and the evidence that's there at the time. I don't know, Rosie, if you wanted to add anything there.
I don't think so, but I think that leads quite nicely on to another question that's literally just come through a couple of moments ago, actually.
Yes.
Does it make any difference if issues were missed or scans overlooked by a rheumatologist rather than an orthopaedic or neurology specialist? And I think the short answer is no. So what we would do, as Julianne explained, is obtain the full set of our clients' records, all of the scans, and that would really enable us to pinpoint who was making the decisions, who was giving the advice. So if in fact it was a rheumatologist when presented with their patient should arguably have referred on, then rather than an orthopaedic surgeon, we would probably instruct a rheumatologist in the first instance to comment on the standard of care that patient received and whether that was in accordance with a reasonably competent body of rheumatologists. So going back to those legal tests, we may well have a breach of duty, but from a slightly different angle to what we've been looking at during the webinar. And if we can say that something should have been done differently by the rheumatologists, then we would move on to looking at what difference it would have made. So probably involving the surgeon at that stage to confirm what would and should have been the course of the treatment if the rheumatologist had picked up what we say they should have picked up.
Yeah, and I think the general thing is if you order a test, isn't it, Rosie, you should follow it up. As such, you know, so you know, sometimes you'll see someone in a different field that's organised something like a scan, then it's up to them to obviously review the scan report and then make the appropriate referrals as well.
Yeah, absolutely.
And then we've had another question that's come through, which is, would misdiagnosis include a surgeon diagnosing, if I can pronounce this right, radiolocopy when the patient actually has cervical myelopathy? So in other words, could that fall within a scope of misdiagnosis? So we do see, don't we, I think, Rosie, the sort of, you know, the sort of milder symptoms with the cervical radiography, you know, initially starting in some of the cervical myelopathy cases that, you know, that we deal with. And you do see a bit of this interchange, don't you? So between you know, the two different kind of conditions. And again, this is from a lawyer's speak, but generally, I mean, they do have some overlapping features. So, you know, when you've got a cervical radiolopathy, I think you'll get your kind of general arm symptoms, your sensory disturbance, maybe a bit of your pins and needles. Where your myelopathy, you've got your more, you know, your classic myelopathy, you've got your hallmark kind of red flag symptoms we talked about, so which will, you know, where this actual spinal cord is being compressed, so you've got more kind of gait imbalance, hand clumsiness, dexterity, you might have bladder and bowel, but again, it's important to suppose is that, you know, that, you know, a full history has been taken and just to check that it's obviously not becoming sort of misdiagnosed. So there could be, we have had cases where radiography, you know, has been misdiagnosed when in fact it's cervical myelopathy, you know, because they haven't picked up on those red flag symptoms, which then should have led to an urgent MRI and an urgent referral. So sometimes you do see a bit of interchange between those two conditions, don't you? Again, it's down to, again, getting that expert evidence, isn't it, Rosie, to have a look at the medical records and what the clinician did and if that was appropriate.
I think I agree, and I think it may well depend on when the diagnosis of radiculopathy is being considered. So is this part of the initial sort of differential diagnosis at the outset when the patient's first being assessed, which may well be appropriate depending on the symptoms that the patient presents with. But certainly as those investigations, those tests progress towards any treatment being considered, the situation may well be different, and to be considering a particular diagnosis that clearly isn't appropriate once further tests have been undertaken, that may well be a slightly different question. So I think it may well depend on when in the course of things those diagnoses are being considered.
Yeah, and it's very specific, isn't it? And depends on obviously, you know, what was occurring, what were the symptoms at the time. And again, that's something that, you know, for example, I think in that question, it was concerned that, you know, would it include a surgeon? And again, you know, again, it would be looking at whether or not on the information before them, you know, the information from the patient, whether or not they carried out a proper examination, and through any red flags that then would have, you know, mandated you know, some further tests and an MRI scan to sort of diagnose that cord compression. And again, that will be judged by if it was an orthopedic surgeon or a spinal surgeon. Again, you know, that would what they would look at, whether or not that was a reasonable view to come to. I'll just check. I don't think we've had any more questions. Let me just double check if anything else has come through. I don't think so. So we're coming very much to our close today. So thank you first and foremost for everyone that's joined and given up your time to attend the webinar today. I hope you found it helpful. I know we've covered a lot of content, but we wanted to get through as much as we could. Huge thanks to Rosie and Sue for taking part in the webinar today, and also to lovely Megan, who's been facilitating it and making sure it's all running smoothly. And again, I hope you found it useful. As we said at the beginning, the webinar has been recorded, so I believe that if you have registered, you should receive a link at some point this week to the recording. Do feel free to reach out to us if you've got any further questions. Again, our contact details. Again, we can send those, can't we, when we've got when we send the sort of link to the webinar, but they were there on the first slide. Also, as I said, we're going to be doing at some point over the next couple of months a legal advice drop-in centre. That'll be a free advice centre. So again, we'll ask the charity to send out details of the dates of when we're going to run those. And then later on in the year, we're going to be doing a webinar on cervical myelopathy. So we get proper medical experts, not me just trying to answer the question, but, you know, we'll get maybe some GP experts to talk about, you know, when people present in a GP with those symptoms. We'll probably also get a spinal surgeon as well, and you know, and sort of look at that, you know, importance of early timely diagnosis, and build a bit of a series around that. And then we'll share details on that webinar a bit later. So it just comes for me to say thank you again very much for joining us, and I hope you enjoy the rest of your afternoon. Thank you.
Thank you.